And hello, everyone, and good morning. Welcome to Uncivil Law, where we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in both Virginia and Texas. It is April the 26th of 2023, and we are here with all the legal news that is going on in your world so that you can be better legally informed. We begin this morning with a trial that is underway in New York regarding a decades-old accusation against Donald Trump relating to sexual assault. Opening statements in this trial have begun for the woman, Jean Carroll, who has accused Trump of a brutal attack that occurred in the past. Trump, of course, for his part, has denied the accusations, but the trial is underway. This civil rights lawsuit begins from a woman who says that this assault occurred in the 1990s. Carroll, who is a magazine columnist, says that Trump attacked her in a dressing room of a luxury department store during the 1990s, committing a sexual assault. Trump, of course, denies the claim, saying the incident never happened. She's also suing him for defamation, for publicly calling the allegations a hoax. She's seeking unspecified monetary damages. All right. So as to the defamation issue, that is an issue that can, of course, turn on state law specific stuff. Typically, although not necessarily universally, a person can't sue for defamation for a person merely denying a claim, right? Because people have a right to deny a claim against them. So while saying that isn't true, could be perceived obviously as a statement of fact that impugns another person's character, many courts say that merely denying an allegation can't be defamation, because if it was, then that creates a whole new set of problems on top of things, right? So statements beyond a mere denial might get you into defamation, but mere denial typically is not a defamation claim. So this might turn very specifically on what Trump did or did not say, beyond a mere denial or beyond mere statements of denial. So it could get into the specifics, but if it's a mere statement of denial, that typically is not enough for defamation. As to the underlying sexual assault, of course, we would have to turn that on a question of fact, like, did it occur at all? Trump says no. The whole thing didn't occur, it's made up. So I guess we'll have to get into a question of fact, and I suppose that's what juries are for. Describing how Carroll and Trump bantered playfully before the alleged assault, Carroll's lawyer told the jury during opening arguments, the moment they went inside the dressing room, everything changed. Suddenly, everything was not funny. Trump was almost twice her size, the lawyer said. He held down her arm, pulled down her tights, and then sexually assaulted her. So, just a straight up claim of non-consent. And the issue isn't apparently consent. The issue is apparently whether or not it occurred at all, because Trump, for his part, has denied it, right? So the issue isn't, oh, she said yes. The issue is apparently whether it occurred at all. So, all right. Trump, of course, is not required to appear for the proceedings because this is a civil case, did not attend for the first day of trial. His lawyer sought to portray the claims as a sick story, while also trying to reassure jurors they could side with him even if they don't like him. Because, of course, whether or not you like Donald Trump or not as a person is completely independent from whether or not he committed this act or not. Nice people do bad things. Bad people don't necessarily do bad things either. Bad people do good people do bad things. It can vary. So whether or not you like him or not is not the issue. You can hate Donald Trump, it's okay, he said. There's a time and a place for that. It's called the ballot box, not here in a court of law. Fair enough. Fair enough. You can not watch his shows, not consume his content, not vote for him. But you should view this question as a question of fact unto itself. Did this occur or not? That's what we're trying to accomplish here. While no one is above the law, also, of course, no one is beneath it. So, yeah, we should try to figure this out. Carroll, Trump's lawyer, says, was motivated by money and politics. He questioned the claim that no shoppers or employees were around to witness the incident and emphasized she couldn't recall details. most notably the timing of the attack. So she's a little vague, apparently, as to when it occurred. So she can't tell you the date, she can't tell you the month, she can't tell you the season or the year. Yeah, I mean, I wouldn't know for sure, having never been in such a situation. But I would imagine being sexually assaulted, I'd have some of those information a little bit clearer. And if this occurred in a department store that no one was around to see or hear it, I mean, there's definitely possibilities, but it raises questions as well, as we're trying to assess whether or not this happened or not. Evidence will show you that Jean Carroll can't tell you those things because the story isn't true. To combat some of those statements, Carroll's, for her part, says that her account is corroborated by two friends who she told contemporaneously. So apparently told at the time. That would normally be what contemporaneously means. So that is not a recent fabrication. That certainly helps. Maybe they can pin down the time. And a former employee who can testify to physical attributes of the store, and that Trump's assault is part of a pattern, which, I don't know about that either, but okay. Two other women have accused Trump of sexual assault, are also set to testify, and they've also received permission to use the famous Access Hollywood tape, which Trump's boasts: when you're a star, they let you do anything, you can do anything, grab them by the P word, you can do anything, as evidence in the trial. So, that might be suggestive of something, I suppose. Trump also said, in disputing Carroll's claims, that Carroll is not his type. He's saying, we all knows what that means. She's too ugly to assault. I don't know if that's what that means or not, but okay. Later in the remarks, she also argued that the comment was not only offensive, but a lie. Describing portions of the videotape deposition they intend to show the jury, Carroll showed jurors a black and white photograph of Trump with Carroll. So, yeah. Okay. Apparently, Trump, when asked about it at deposition, mistook the woman for his wife. So he apparently it is his type, because it's so his type that he thought that the woman in the photograph was the woman that he married. So apparently that's a thing, confusing the person for his own wife, because apparently they're so close and looking like each other. So fine. The trial is expected to last between 1 and 2 weeks. Testimony expected to begin on Wednesday. Trump isn't expected to attend the trial, of course, and the U.S. District Judge, who took court filings in issue with this, advised lawyers to warn their clients against making remarks that inspire violence, because, why not? Thus, that brings us to the end of the story for the moment about this case regarding a sexual assault that apparently occurred sometime during the 1990s, but the victim themselves is apparently unsure about what year it occurred, or month, or day, or even what season of the year. But she does believe that she knows where it occurred. There doesn't appear to be any witnesses to the assault, though there does appear to be some people that she told, apparently relatively contemporaneously to the event. So, although I guess we would have to dispute whether or not it's contemporaneous or not, because how do we know it's contemporaneous without knowing when the event occurred? But she says it is, so I guess we'll figure all that out. So this is underway in a question of fact. Did the event occur at all? Is the underlying question of fact for the moment. Trump says none of this is true. The woman, of course, says it's true. They're photographed together, so they know each other, but whether this event occurred or not, trying to get to that question of fact. This is a civil case, of course, so the question is preponderance of the evidence, 50.1%. Which is more likely than not? Is it more likely than not that it did occur or didn't occur? Is the underlying question of fact the jury has to figure out in this case. And that, for the moment, brings us to the end of discussion of this story. Good morning, everyone, and welcome to Uncivil Law. As always, I hope you're having just the most uncivil day possible, because that's the best kind of day to have. I'd like to begin by thanking everyone collectively because this channel has passed 10 million collective views. That's nice. That feels like a big number. That feels like an accomplishment. 10 million times. 10 million times you people have made the foolish decision to click on my videos and watch them. Wow. Thank you so much for your fun. Thank you so much for your participation. And thank you for enjoying my content. I hope it's brought you a lot of entertainment, a lot of education, a lot of fun. I hope you enjoy me personally, all that good stuff. Thank you so much for your continuing support. And for the 123,000 of you who are subscribers, I do appreciate. We try, or at least I try, because it's a one-man show. I try very hard to make this stuff better and more interesting and more fun, and to try to make it more educational and more entertaining, and just try to do all the things and experiment with different things. Like, for example, this morning roundup thing that we're doing now, going into our third week. That seems to have been relatively successful as an endeavor. So, hey, when things work, we keep doing them. And so we will continue doing things as they work. We appreciate all of you. Thank you, Alan Parker, as always, for your memberships and buying memberships for the channel. We do appreciate all the people who are the uncivilians. And you too can show your support by being an uncivilian. It couldn't be easier, my friends. All you have to do is hit that wonderful join button, or hit the link that the bot tells you about from time to time, where it's like, join, become an uncivilian. Click the link, click the join button. It's only 99 cents a month. It's literally the least YouTube will let me charge you, because I'm trying to make this accessible, not for least of reasons that I personally am well aware of how much those membership fees can add up when you're supporting a whole bunch of different creators. When you're supporting a whole bunch of different creators at $5 a month, that can add up pretty fast. I've been there, right? So it's like, I don't want to make this problematic for you. So I'll make it 99 cents a month, because, hey, that's not so bad. And you can support me for 99 cents a month. What do you get for your 99 cents a month? Well, you get your name in green. You get some cool scales by your name. That's cool. You get access to some emojis. That's nice. You get access to some member-only content, typically gaming streams, things like that. And also you get my love. And also you get that sense, that little warm feeling inside that you're helping an independent creator create. And that's nice. So you get all those things. And we'll think of more things to give, but hey, all that good stuff. Good morning to Sandra Ramirez. NJS55 Nikki is here. CTY is here. Spring Storm is here. We've had some spring storms recently in Texas. Good morning to you. Glinda is here. Linda, yeah. Sarah's here. Thank you. Wishing me congratulations on the 10 million views. Sarah, that's very kind of you. Neham is here. Trigger Warning is here. Angie Smith. Calbo. Nikki became a member. She became a member. You can become a member just like Nikki by hitting that join button. We appreciate everyone who helps to support the channel. Jillian is here. Good morning, Jillian Maloney. Hope you're having a great day. Rena is here. Can we have a regular cooking stream? Maybe we should. Maybe it should be like a weekly thing. Maybe we'll do that. It could be weekly cooking with Kurt. Not the worst idea I've ever heard. Maybe we'll do that. I will contemplate it. Only if you guys are good, though. I will only do a cooking stream if you guys click the share button and share the daily streams on the Twitters and other social medias, and you promulgate the word of the uncivil law. Only if you do that. If you do those things and you're good, maybe we'll do a weekly cooking stream. That'll be fun. Tammy is here. Thank you, Generous, longtime supporter of the channel. Thank you, Generous. So proud of you, 10 million views. Thank you, very nice. Hope I do something nice to celebrate. I'm hanging out with you. That's a nice thing to do. I love you all. Tammy is here. Rick is here. Wendy is here. Michelle is here. Shirori is here. Green is my color. I don't know if it's my color or not, but I try to look nice and make the background try to complement what I'm wearing. Try to think about these things a little bit. Try to think about things a little bit like that. Heaps is here. Cobalt Annie is here. Eddie, oh holy hell. Nice to have you here. Foster Cathead, B. Davis. Jelly Bean. Jelly Bean is here. We like jelly beans. They're nice. Good morning, everyone. Jude says, okay, I'll join. You deserve support. You're the smallest lawyer I watch, and you cook good. Thank you. Thank you very much. I appreciate all those things. You all kick ass. And thank you also, by the way, for the orange hearts and cowboy hats emojis. For those of you who maybe are unaware, the various members of LawTubes at one point basically collectively agreed on our various emojis, and I picked 2 because I'm greedy. But yes, we collectively picked various emojis to represent us. So the idea would be, as I appear in other people's chats or stuff, or as they appear in my chats or stuff, you would show their emoji to show some love. And so I picked the orange heart because I'm a Clemson grad, so orange, and also the cowboy hat because, well, obvious reasons. So if you like to show support, the orange heart and cowboy hat are the preferred emojis to represent uncivil law. So yeah, great. Do I have people I could invite for a milestone celebration? Yeah, maybe. Yeah, could be fun. Yeah, I just don't know what we'd talk about or what we'd do exactly, but yeah, we could have a stream where we could hang out and stuff. It'd be fun. All right. The U.S. Supreme Court has denied review in a case dealing with oil companies' liability for various things that could be linked to climate change under various state laws. So a bunch of jurisdictions are trying to sue oil companies and other people relating to climate change, arguing that somewhat like big tobacco back in the day, the oil companies are aware of the damage that they are causing, making statements inconsistent with that, causing environmental harm, causing tragedy of the commons, that kind of thing. And this is going on in a lot of different places. So one of the things that the oil companies have tried to do is to bring this into federal court for a lot of reasons. And not the least of which is that, well, then you're dealing with one set of laws, federal law, and then you wouldn't have to deal with the individual laws of the individual jurisdictions. Well, these lawsuits have been going on for a couple of years at this point, but the U.S. Supreme Court has denied the ability to get into federal court. And so these will now, at least for the moment, continue to persist under state law, which provides a lot of exposure to the oil companies, not for least of reasons now that they have to fight these assaults in multiple different jurisdictions with multiple different laws and multiple different rules. So it complicates the case that they have to defend. So it's somewhat of a big deal. There's a lot of litigation left to go, but it's a pretty big notable deal that this is going to persist, at least for a moment, in state court. The U.S. Supreme Court on Monday declined to hear the bids by the oil companies in relation to these lawsuits, which are beginning to percolate in a bunch of different places. The appeal was made by different oil companies, including Exxon, Suncor, and Chevron. The justices turned away 5 different appeals from oil companies relating to these things in various state courts. So, as I say, these have been going on for a while, and a bunch of them sort of reached a climax at roughly the same time. And 5 different ones went to the US Supreme Court at roughly the same time. And the Supreme Court turned down intervention in all of them. The lawsuits that were at issue in this particular series of cases comes courtesy of Rhode Island, Maryland, Colorado, California, and Hawaii. So now those will have to persist in those respective state courts, at least for the moment. Numerous state and local governments, of course, have pursued these actions against oil companies, and these could cause to be regulated more or could cause some sort of monetary damages or something. So there's a lot of law left to go, but this decision is pretty notable for the interim. This appeal had marked the first chance for the Supreme Court to decide whether or not to get involved in this current set of issues for the first time since 2021, when justices gave oil companies a new shot at redirecting climate change suits into federal court. So the Supreme Court gave the oil companies an opportunity to get into federal court, or a revised opportunity, but they weren't able to take advantage of it. In the 7-1 ruling by the US Supreme Court in 2021, the justices concluded the federal appeal court had not correctly analyzed where the lawsuit brought by Baltimore against the various companies should be heard in federal court. That decision, of course, as one would expect, caused other federal courts to reconsider whether they should send them to federal court or state court where they were originally filed. So the Supreme Court says, okay, look, federal courts, you haven't looked at this properly. And so, unsurprisingly, all the federal courts say, okay, let's try to figure out whether or not this should be heard, where this should be heard. Those cases that were being decided by the Supreme Court included one in 2018 by Boulder, accusing Exxon of exasperating climate change by concealing and misrepresenting dangers. So some of the similar theories or similar ideas that you saw in relation to tobacco, right? Misleading, concealment, deception, that kind of thing. So that, and causing all this harm as a result of it. The lawsuit said companies create a public and private nuisance. That would be a typical way of going about this, right? Nuisance. An example of nuisance would be, for example, your neighbor is burning things on their property and the smoke comes onto your property, right? That's a nuisance, right? Everyone sort of has rights to their own property. And so if your neighbor is doing something on their property that impacts your property, that's what a nuisance is, right? A private nuisance obviously would be the example I just raised. Your neighbor is burning things and is causing smoke on your property. That's a nuisance to you privately. Public nuisance would be the same idea, but for the public at large. You know, you're causing harm that is beyond your own rights. So yeah, nuisance law certainly makes sense as a method of going about this. Also saying that they violated state consumer protection laws, as jurisdictions have tried to force the oil companies to pay for some of this. The oil companies, of course, for their part, have denied allegations and moved the lawsuits to federal court, saying local governments made their allegations under state law in an attempt to conceal real federal issues. So this is not, of course, an atypical idea or an atypical response, right? So what you're trying to do is really a cover for something else. You're trying to bring this under state law, but this really is federal law, or federal law preempts. So you're trying to say, state nuisance law, state consumer protection law, that kind of thing. But really the issue is national in its nature, because the nature of the harm is climate change, which by its own terms presumably persists beyond state boundaries, and therefore would be more of a federal issue. So the idea is, okay, this is really a federal issue, and you're just trying to use the state issue as a way to get past it so that you can deal with it in your own courts rather than dealing with it where it belongs. So a question of jurisdiction, a question of venue, a question of preemption. So yeah, that makes total logical sense as to why you would be doing that. The Denver 10th Circuit Court of Appeals concluded the lawsuit did not belong in federal court because none of the grounds cited by the company changed venue supported federal court jurisdiction. So the federal courts are like, nah, no, not in this particular instance. These issues are state issues. 4 other appeal courts reach similar conclusions. So yeah, they're looking at this issue, and they're looking at the guidance from the Supreme Court as one does, and 5 different courts of appeal say this should be in state law. None of them apparently disagree. So the oil companies took the 5 agreeing opinions to the US Supreme Court anyway, and the Supreme Court told them to go away. So the Exxon and Suncor lawyers argued the Supreme Court should take up to see whether it's a federal common law issue for these issues, but the Supreme Court said no, go away. So all these cases will continue to persist in state law, at least for the moment. Thus, that brings us to the end of this case for the moment about the oil companies. The oil companies are sad because they're being sued in many different state courts relating to state law claims, such as nuisance, which is a kind of trespass, basically, or consumer deception, or other state law torts. And the oil companies are like, hey, wait a second, this is really a federal issue, because your issue apparently is climate change, which is, more than state in its focus. So this really should be a federal issue. The US Supreme Court issued some guidance on this in 2021, and then 5 different courts of appeal looking at the guidance said, no, this is actually a state issue. This is not federal in nature. You have not made a case for federal action. And then the oil companies took all 5 courts of appeal decisions to the US Supreme Court, who told them to go away. So these issues will continue to be resolved in state law, at least for the foreseeable future, which of course makes the oil companies sad and frustrated, as now they have to defend against 5 different lines of attack under 5 different jurisdictions' laws rather than one unified attack. So things are not going great for the oil companies, and that, at least for the moment, brings us to the end of discussion of this story. Fantastic. And Enco Lion in chat says they bought an e-bike and it's the best thing ever. I've used e-bikes before, and they're pretty kick-ass. So yes, I'm happy that you bought an e-bike, and I'm happy you like it. That is good. I hope you continue to like it and ride it around parks and lakes and stuff. That'd be fun. That'd be kick-ass. Enjoy your bike. Udo says, I think I've been a member of 4+ months, but those were gifted. Do I wait until it expires until it joins? No, I don't think so. I think you can join at any time. And no, you should absolutely not wait till you expire. If you haven't, in fact, you should consider options beyond the 99-cent tier. Did you know there are options beyond the 99-cent tier? It's true. You can also support at like the $5.99 tier and other tiers if you'd like to express your love in higher levels. There are higher levels than the 99-cent tier. So maybe consider upgrading your membership. That'd be good. Or otherwise, you should absolutely not wait. You should join, renew, increase your membership level today. You should definitely do those things. Do it now. All right. Sandra, being kick-ass here, reminding everyone to subscribe and have notifications turned on. And also, just as a reminder, by the way, you can subscribe to my Twitters, because Twitter, because I have an automated notification that goes out on Twitter, and I almost use Twitter almost exclusively for that purpose. I occasionally do tweets or respond to other tweets, but principally like 90% of my Twitter is just sending out notifications relating to the stream. And it works every single time, which is nice. So if you're not getting YouTube notifications or you'd like an additional way to get notifications, subscribing to my Twitter is a great way to get notification because it will send out a notification letting you know of a stream or upcoming stream or video or things like that. You can also subscribe to my Discord and get notifications that way. Although I keep threatening to shut the Discord down. So I don't know if we will rely on that because, but the Twitters I think will remain indefinitely. So you can get notifications that way in addition to the YouTube notifications, because I know that's a problem for some people with YouTube notifications. So get it on Twitters. And I think also it sends out notifications on Facebook as well. So if you're really old school, you can get it on Facebook. So there's that option. So yeah. Jerry asked, what are your thoughts on the case the Supreme Court's going to hear about seizing a house for an unpaid tax bill? Yes, they've heard that case, actually. They heard oral argument yesterday, I believe, on that case. And I am planning on doing a Supreme Court oral react on this case. So for those of you who are unfamiliar, this issue, of course, as you would expect, goes beyond the woman in question, right? So what happened here, what happened is this woman owes the government some money. Okay? She owes the government some money. In order to pay off her debt, the government seizes her house as an asset. Okay? They sell the house in order to get the monies. Now, here's where the bad part pops in, right? They sell the house for more than the debt. So the amount that they sell the house for is more than the debt. Do they refund the money? They do not. They keep all the money. They're like, yes, we got more than we needed, but we're keeping all of it. And like, that doesn't really make sense to me at all. How does that work? Right? How does that work? It's like, yes, we'll just keep all the money. That doesn't make any sense. Seize the money. It doesn't also make sense, incidentally, under like consumer law. Not that the analogy is necessarily perfect, but if, for example, you have a car, because this would be the most obvious way it would pop up in people's lives, right? This would be the most obvious way it would pop up in someone's normal life, right? You buy a car, you buy it on debt, you buy it on credit, as many people do, right? You buy your car, you buy it on credit, as many people do, and then you stop paying the car loan. So eventually they come and take your car and they sell the car to pay the debt, right? And if they sell the car for more than the debt, then they have to give you the excess. That's under the UCC, right? They have to sell it in a commercially reasonable way, which typically means auction. So you're probably not going to get as much for the car as you maximally could, but they just have to sell it in a commercially reasonable way, which typically means auction. But if somehow the car sells for more than the debt, they have to give you the excess, but somehow not the government if this exact scenario happens, which doesn't make sense. So yes, we will definitely cover that case for sure, because that sounds like some bullshit. So yeah. What do you get for, someone asked, Sarah says, what do you get extra for higher tiers? More of my love. You get more love and you get a stronger sense of support and a stronger sense of feeling good about yourself. You get even a warmer, fuzzier feeling inside from additional support. So that you get stronger feelings of love. And hey, the Beatles said you can't buy love, but the Beatles were wrong. You can buy love. You can buy it for higher tiers. More love is what you get. That's great. All right. Thank you, Celebrell, for becoming a member. We do love everyone who becomes members. Yeah. Yeah, good times. Cow poo is not an F bomb, but yeah, bullshit is not an F bomb, but can get a like. Yeah. Yeah. So yeah. Sing Higher Love for red tier. I could do songs. Yes. Okay. So if you join at a higher tier, you can request karaoke. Sure, that works. And I might, and it has a higher chance I'll sing for you. Yeah. All right. The courts in Iran have reached a judgment against the United States. The Iranian courts have said that the United States and Obama personally owe Iran $313 million for attacks in Iran. Lol. So yeah, apparently Iran thinks that we owe them money. Uh-huh. Sure. Great. Uh-huh. Let's see you collect on that one. The Iranian court has ruled the United States government and numerous individuals, including Barack Obama, must pay for 2017 attacks carried out by ISIS. So apparently it wasn't even things the United States itself directly did. It was ISIS, but we're responsible for that. The court issued the verdict based on complaints by families that were killed in Tehran in 2017. The building of the Iranian parliament and mausoleum of Iran's former leader were targeted during the daylight assault. The court ruled that $10 million need to be paid in compensation, $100 million and $200 million respectively for moral and punitive damages. Those cases involve the US government, Obama, George W. Bush, CENTCOM, its former commander, the CIA, the Treasury Department, Lockheed Martin, and American Airlines. Amazingly, of course, none of those entities hold any assets under Iranian control because the United States has had an embargo on Iran forever. So, amazingly enough, none of those people have any money or assets under Iranian control. So, yeah. As to why the United States and these various people are apparently responsible for the ISIS attacks, apparently, according to the courts, American officials played a fundamental role in organizing and guiding the terrorist groups, including the CIA by creating them. Uh-huh. The judiciary also acknowledged the ruling comes as a response to numerous orders by U.S. courts that blamed Iran for terrorist attacks and ordered compensation pays seized from Iranian assets, which, yeah. As this marks a violation of the immunity of Iranian's government, Iranian courts have also judged against the United States. Uh-huh. That should go over super duper well. Thus, that brings us to the end of this discussion about Iran apparently saying that various officials in the United States, Lockheed Martin and American Airlines, for some reason, I'm not 100% sure how American Airlines got into this, but somehow they did, owe Iran $300 million, which they absolutely cannot collect. And so, yeah. So that is just a thing that apparently happened. And that brings us to the end of the discussion of this story. Uh, as Jeremy Clarkson might say, oh no, moving on. Good times. American Airlines participates in transporting troops sometimes. Sure, I guess I don't know how American Airlines gets into this, but sure, uh, fine. I messed up the line. Did I mess up the line? It's not oh no. Anyways, or is it and no oh no? Moving along. What is the line? Oh no, I screwed up the line. Yeah. Oh no. Anyway. Okay. Oh no. Anyway. Chief Justice Roberts has sent a let's try that line again. Let's try to say it again, like competently this time. Chief Justice Roberts has formally declined to participate in Senate hearings regarding ethics inquiries. So, yeah, there's been a lot of consternation recently, as I'm sure many of you are aware, regarding the ethics at the Supreme Court, particularly as it relates to Justice Thomas and receiving money from a friend slash donor slash influencer slash whatever, and whether or not those were properly disclosed and all the rest of it. So the Senate Judiciary Committee wanted Chief Justice Roberts to either appear or send someone, and Chief Justice Roberts like, we'll pass. So yeah, all right. Chief Justice Roberts has declined a request from the Senate Judiciary Committee to testify on ethical standards at the court, instead providing the panel with a statement of ethics reaffirmed by the court's 9 justices. The Senate Judiciary Committee Chairman Dick Durbin of Illinois invited Roberts' testimony last week, saying that there had been a steady stream of revelations regarding the Supreme Court falling short of ethical standards expected of other federal judges, which that is kind of true because the Supreme Court is not bound by the same rules of ethics that bind other federal courts. So that's true. Not for least of reasons, because of course the Supreme Court is sort of the head of the totem pole. So who can judge them on some level? But yeah, there's a problem there. The invitation from the Senate came after news reports regarding Clarence Thomas and a conservative donor from Texas whose name is Harlan Crow. The donor had purchased properties belonging to Thomas and his family in transactions that were worth more than $100,000, but never reported, and also apparently gifted things, including trips and vacations and things, at least according to the zeitgeist. Now, that isn't necessarily a problem, although it isn't necessarily not a problem, right? Because you get into issues of maybe this is influence peddling and stuff like that. So you have someone who is a notable influencer in conservative and GOP circles who is doing business with Thomas, presumably to try to gain some favor or gain some things, although this guy's also been a friend of his for 25 years. But maybe it's a friendship that is designed to entice things. So you get into all kinds of weird issues on these things because obviously justices are allowed to have friends. I mean, that goes without saying, and friends can do nice things for each other. But of course, when you're a friend in high places, it does raise at least an eyebrow of concern. In a letter to Durbin, Roberts said he respectfully declined the committee's request. Testimony before the Senate Judiciary Committee by the Chief Justice is exceedingly rare, which that part is pretty true. As Justice Roberts himself pointed out in the letter, the Chief Justice of the U.S. Supreme Court has appeared very rarely for any sort of congressional hearings. And when they have, they've been sort of ancillary or they've been sort of more relating to what you might consider absolute core functions of the court. So the Chief Justice has not often appeared before Congress because it raises separation of power concerns, obviously, because you have the legislative branch now trying to do things in relation to the judicial branch and their independent branches of government. So on the one hand, of course, the Senate has some oversight role, but on the other hand, the judiciary branch has the right to maintain its own power base. So, not unexpected, but maybe perhaps disappointing to some. Accompanying the letter was a statement on ethical practices signed by all 9 justices describing rules they follow. And the rules, of course, are not new, but reaffirm their responsibilities. The statement details standards for justices for recusal, but of course doesn't require just to state why they're being recused or why they're recusing. Durbin, for his part, said he would continue with the hearings, which will review common sense proposals to hold Supreme Court justices more accountable. So, okay. So the Senate wants to get involved in this and hold hearings, and then if they pass some sort of legislation on it, then, we have to get into issues as it relates to separation of powers and proper review or things. But, the Senate gonna Senate for at least the moment. So we'll see how that goes. ProPublica has reviewed that the same individual who bought the properties from Thomas has also gifted Thomas and his wife apparently hundreds of thousands of dollars of vacations and trips over decades, because again, they've been friends for 25 years, including international cruises on his mega yacht. That's nice. Private jet flights and stays at his invitation-only resort. But the 2014 real estate deal is the first public evidence of a direct financial transaction. So, yeah, there's all these gifts to Thomas and his wife, and it's like, okay, what is really going on? Ethics experts have offered conflicting views about whether Thomas was required to disclose the trips. So, yeah, that because it's not 100% clear. He doesn't appear to have any business directly before the court. So there doesn't appear to be a conflict in that way. Thomas said in his statement he was advised that this sort of personal hospitality from a close friend who doesn't have business before the court was not reportable, which it very well might not be, even under the comparable guidelines for courts or executive branch officials, right? If they don't have business before it and it's just a friend, then it is probably not reportable, at least under the standard ethics guidelines. So, yeah, there's conflicting views from ethics experts on this one. Thomas might be technically in the right, which may raise its own set of concerns, incidentally, which might be why the Senate wants to get involved. Because even if Thomas is right under the current rules, maybe we need different rules. Jules Buddha gives 10 memberships to support the channel. Thank you, Jules, for your continuing support. I've seen your name before, along with other people showing continuing support for the channel. Of course, Ellen Parker being a huge supporter of recent days. We really appreciate all those supporters. It kicks ass. I love you all. Last month, the federal judiciary bolstered disclosure requirements for all judges, including the High Court, although overnight stays at personal vacation homes owned by friends would remain exempt under the new modified rules. The Ethics Committee said Durbin notes the Judicial Conference have provided clarification on the scope of personal hospitality exemption relating to disclosure rules. So, yeah, whether this is personal or whether it's not. In declining to testify, Roberts also took a pass on the possibility of some other justice appearing in his stead, because the request said you could appoint someone else. And there had been some suggestion maybe we get Justice Breyer to appear, because Justice Breyer loves the Senate and loves talking about this kind of shit. So maybe Justice Breyer would appear, or maybe he'll still appear anyway. They could always ask him separately. We'll get Justice Breyer involved, see how that goes. The last time justices met with the Senate Judiciary Committee was in 2011 when Scalia and Breyer testified before. So yes, so it doesn't happen very often, but maybe we'll see Justice Breyer make an appearance again. That would be fun. Thus, that brings us to the end of the discussion about the review of Senate ethics. Let's try that line again. Thus, that brings us to the end of the discussion for the moment about the Supreme Court ethics review and all the things going on relating to that. Justice Thomas accepted money, both in transaction form for the selling of property and also as just straight up gifts from a person who has been his friend for 25 years. So, I mean, they've had a close relationship. The person doesn't have any direct business before the court, but the person is a influential person in the conservative Republican circles. And so maybe this is some sort of softer form of influence peddling, or maybe not. Maybe it's just a friend because, hey, Supreme Court justices can have friends too. So I don't know. And the Senate is taking a closer look at this and some of the rules that involve such things and what the rules should be. So they will discuss that, at least for the moment. That brings us to the end of discussion of this story. Words are sometimes hard, but it is not a Monday. Sometimes words are hard. Sometimes we forget the right words. Thank you for being a friend. By the way, if you want to be my friend and gift me trips on yachts or international travel or spots at invitation only places, I am available. I am available for this kind of friendship. You can sponsor my trip internationally. I can go visit Alita. I can go visit Legal Vices and Legal Mindset. You can sponsor my whole LawTube tour. Ian in Canada. We'll set out dates. We'll do like a rock band thing. It'll be great. We'll make up some t-shirts, right? We'll make up some t-shirts with some dates. Internationally LawTube tour. It'll be great. If you'd like to sponsor that, drop me a line at uncivillawllc.com, Kurt at uncivillawllc.com, and we can do all that stuff. That'd be great. All right, let's see what else do we have today that isn't a major depressing story. Let's see. Depressing. No. Oh, okay, we'll cover this one. We'll do this one. Okay. $50 from Sandra Ramirez. That's very nice. Thank you, Sandra. I'll buy some love. Congratulations again on 10 million views. Hard work pays off. Well, thank you, Sandra. That's really, really nice. That's really, really generous of you. Thank you, Sandra. That's very, very kind of you. Thank you so much for all your love and support. Everyone, I appreciate it. Thank you. Is there more Florida Man stories? I didn't actually look up a Florida Man story today, which is funny. Let's look up a Florida Man story real fast. Let's see. All right, this looks promising. Okay. Yep, that'll work. Easy. Easy. What do I think of Microsoft buying Activision? I have no particular thoughts on the issue. That would give Microsoft a monopoly? I'm not sure if I see that, but okay. I mean, fair enough. Let's do this one. Sony's trying to stop the purchase? Well, yes, I figured as much. So, I don't know. I don't think so, personally, but that's probably more of a Hogue question. That's fair. Hogue would have a more informed opinion on this issue. So, I'll defer to Hogue on this one. He'd be more the subject matter expert. Pinkerton's being sent to raid someone's home by Wizard of the Coast? Wow. That's a lot. That's a lot. All right. The Sixth Circuit Court of Appeals has rejected the bump stock ban. This, of course, has been an issue that's been percolating, and various courts have taken a look at the proposed bump stock ban by the ATF. And the Sixth Circuit has taken a look at this and said, hey, no, you can't ban bump stocks. The Sixth Circuit decided a case on the 25th, yesterday, concluding bump stocks is not a machine gun or part of a machine gun. So therefore cannot be regulated as a machine gun, which is what the ATF was trying to do. They're trying to say that bump stocks are a machine gun, which is slightly less ridiculous than it sounds on its surface, because machine gun by law would also apply to various machine gun parts, but not this, because they say it's not a part. So here's how the judge writes the argument. The placement of a bump stock, by the way, for those of you who are unfamiliar with the term, a bump stock is basically a device that's designed to use the recoil force of a rifle to help in pulling the trigger. So basically, I'll try to describe this technically as simply as I can. Basically, you put it in the rear of the gun, and sometimes you put it behind the butt of the gun. So when you fire a projectile from a rifle, for example, right, the bullet goes this way, but Newton's laws say that equal force goes this way, right? So Newton's laws to the rescue, right? Equal and opposite force. So bullet goes this way, but recoil comes this way. So the recoil force causes the bump stock to pull the trigger, and basically allows the gun to be triggered as fast as the gun would cycle, but it's not as fast as a machine gun. A machine gun would cycle faster, but and a human being could do this. So a human being, and you can train yourself to do this to some degree. So you don't need the bump stock to do this, right? If you can use, of course, other implements to do this, and you can actually do it just by proper positioning of your hand to achieve the same effect or similar effect. So it pulls the trigger faster in some senses, but it doesn't turn a semi-automatic into an automatic, because you still need to pull the trigger every time. So that's the difference, right? It's a device designed to help you pull the trigger faster, but it still has to pull the trigger, which makes it still a semi-automatic gun. All right, so now that I've tried to discuss that as simply as I can without botching it too hard, the placement of the bump stock causes the rifle to function similarly to a machine gun, and possession of a machine gun is a criminal offense. This raises the question of whether it's a machine gun part. This question is close, on which reasonable people have disagreed. A disagreement caused by ambiguities about how the statute defines the term machine gun. Yeah, that doesn't help either. The statute, like many statutes, is ambiguous on this issue, which again makes the ATF's initial claim that the bump stock is a machine gun less absurd than it might appear, because the statute is open to interpretation, including this one, by the way. So, yeah. So the judge says, but under these particular facts, it's not a machine gun, which makes sense. This, of course, is not the first time the Sixth Circuit has ruled this way. A prior panel reached the same conclusion. The court then granted rehearing and split 8-8 on the issue. So maybe this will go en banc as well, and we'll see whether or not that decision withholds. Thus, that brings us to the end of discussion for the moment about bump stock bans, which are percolating their way through the courts as we try to figure out whether or not this is a machine gun or not. And we're looking at all that and the ambiguity of the statute and the ATF and what they're trying to do. So this issue will eventually wind its way up at the Supreme Court, I'm sure. At least for a moment, that brings us to the end of discussion of this story. Sandra says, I explained it better than my police officer husband. Outstanding. Outstanding. All right, what else do we want to do? We have a whole series of depressing. I wish there was more to this story. A little thin. I'll just tell you. We won't write it as a story, but I'll just tell you. The Foundation for Individual Rights of Expression sued a Michigan school district because it tried to prevent students from wearing Let's Go Brandon sweatshirts. So, according to the lawsuit, 2 middle school students wore the sweatshirts with the phrase, and administrators apparently allowed students to wear apparel with other political messages, but not that. So, that's all there is about that one. All right, let's see. Do you want to know about the killer clown suspect who pretended to deliver flowers and balloons to a husband's then wife before killing her and pled guilty? You, you want to know about? Do you want to know about a woman dressing up as a clown to kill a man's wife? Killer clowns are real? Yeah, I suppose they are. All right, let's do this thing. A woman has pled guilty to murder in a killer clown related scheme. The woman pretended to be a clown, dressing up as a clown, in order to deliver flowers and balloons to a husband's then wife before killing her. So her scheme was pretend to be clown, dress up as clown, deliver flowers and balloons, murder woman. So killer clowns are apparently very real. Here is a picture, apparently, of a killer clown. A woman pleaded guilty on Tuesday to killing her husband's then wife while wearing a clown costume and pretending to deliver flowers. That is a lot of envy, man. I want to be this guy's wife, but she's married. He's married. Let me kill her, and then we can get married. Wow. Wow. The defendant, 57, took a deal for lesser included charge of second-degree murder. The judge sentenced her to 12 years with credit. So she'll only have to serve an additional 6 years, I guess. Wow. 33 years after the murder. Today, we've apparently accomplished some stuff. So apparently this happened 33 years ago. Prosecutors in Florida say that it was the woman who wore a clown costume and makeup to the home of the woman. The victim answered the door. The defendant, then known under her last name, gave the victim balloons and flowers before shooting her in the face and driving off in a Chrysler. Okay, so this woman had a plan: deliver balloon flowers and then shoot the woman in the face. The vehicle apparently was found abandoned several days later in a Winn-Dixie parking lot, which is a grocery store, with trace evidence including long brown human hairs and orange-like fibers that matched hair and fibers found in the apartment. The car belonged to a local dealership belonging to the husband. Apparently, the woman was a repossession agent who operated her own company and did jobs for the husband. Wow. So she repossesses cars, used one of the repossessed cars to commit the murder. Prosecutors say there were witnesses who can place them together in the months leading up to the death. They're also seen going in and out of the apartment and engaging in intimate interactions. So apparently she was the other woman. She didn't like being the other woman, and she decided to murder the wife in order to get married to the guy. Dude, that's a lot. Prosecutors say that witnesses picked the person from a photo array as a person who purchased a clown outfit and makeup. One person who spoke to investigators said the person resembling the person purchased similar balloons and flowers the morning of the murder. The defendant ended up marrying the person, the husband, in 2002. The couple ran a restaurant together in Tennessee and lived in Virginia. Dude, that's a lot. Dude, how do you feel if you're this guy? I mean, that's gotta fuck you up a little bit inside, man. I married my wife's murderer? Dude, that sucks. That sucks hard. Wow. The decision to negotiate a plea deal was made after considering the age of the 33-year-old case, particularly a key witness who died. Also, the lead crime examiner broke the chain of custody for critical evidence and could no longer be authenticated, which, for a 33-year-old case, this is sometimes things that happen. It's not necessarily anyone's fault. But, it's hard to perfectly preserve stuff for 33 years. It can be done, but it's also possible for things to get screwed up. So, the son apparently briefly spoke at the hearing and confirmed they approved of the deal, but there apparently was no signs of remorse from the woman. So, yeah. And authorities never charged the man in the wife's death, so if he was responsible in any way, they are unable to prove it. Wow. Thus, that brings us to the end of this story about the killer clown murder, who only gets sentenced for 12 years and having served 6 of them already, only has to serve an additional 6 years, which is kind of depressing for what seems like a very, very planned murder. But evidence deteriorates, witnesses die, investigators sometimes screw up, so the evidentiary chain was a little bit weaker. So the prosecutor cut a deal to get a conviction on their books of some kind, which makes perfect logical sense. It's not ideal, but makes logical sense. So, yeah. So she pled guilty to that, and that brings us to the end of discussion of this thing. All right. What's going on? Secret McSquirrel? No, really? Well, apparently Secret McSquirrel died. I I'm heartbroken. I don't know how to respond to this. Let me see if Ian can come on and talk about it. All right, I just sent Ian a text message to see if he can come on stream and talk about it. Secret McSquirrel, for those of you who don't know, has been a longtime moderator of not only this channel, but pretty much all of LawTube. I'm not quite sure exactly how it happened, but somehow, some way, Secret McSquirrel basically became chief moderator for basically everybody. I'm not exactly sure how it occurred, but she warmed her way into our hearts. She was incredibly kind, supportive, thoughtful, and she was a very positive voice. She was someone who supported the channel and someone who made me better. She was a source of strength and support for the channel. And, you know, she'd been suffering from cancer. And she had been in and out of the hospital and had only recently gotten discharged from the hospital again. And apparently, according to Ian, has died. That sucks. What is her real name? That's a good question. If she's private and didn't want the information posted, yeah, fair enough. So I won't share it because she didn't want to share it. I don't know what else to say. She was just she was a constant source of good. She was a constant source of support. She was a unifying influence for LawTube. She was someone who I trusted. Yeah, send me a DM, please. Would you, Kristen? I'd appreciate it. She did have a GoFundMe to help get money together for taking care of her house. That sucks. Okay. Ian says he can't come on today. So, yeah. I appreciate you guys letting me know. Just really bad news. This is horrible news. I'm just trying to write a tweet right now. Tweet, tag a couple people on Twitter. Thank you, Kristen. I appreciate it. I think who else I can tag on Twitter that would want to know. And I'll just tag 3 people and call it a day for a moment because I can't think of who else to tag. Uh, well, is she a moderator for Tug? I bet she was. I don't know what to say. I don't know what to say. Just share some of your comments for a minute. See some squirrel emojis in chat. Oh, I'm not trying to. Um, Rainbow Heron. Yeah, I'm with you. This is devastating news for sure. Nicole, she'll be missed. Her ever presence in social media sorely missed. Yeah, yeah. This is sad to be sure. Yes. Sandra, thank you very much for your support as always. Thank you for the squirrel emojis. And David, thank you for the squirrel emojis as well. Trisha. Yeah. Janet says we were kind to her, helped her when she needed. She'll be missed. Yeah. Squirrel only brought light to every chat. That's true. She really, really did. I'd sent her some stuff to her house. I sent her a stuffed squirrel, like a. I sent her a, a cloth stuffed squirrel kind of thing. Sent her a shirt. Sent her some squirrel earrings and squirrel notebook, squirrel a bookmark, and I think some other things that were squirrel related as a thank you. Kristen, heartbroken. Yeah. Don't know. I tweeted Ian's notice or retweeted it. I retweeted Ian's notice uh, on Twitter, obviously. If you guys could retweet it and tag anyone else you think needs to know, that would be a nice thing to do because people need to know. And so if you could help do that, that would be nice. Sandra, thanks for the support. I am obviously not trying to grift off of this at all. Um, I just am trying to process this as best as I can, and but I appreciate support and all the rest of it. Um, she was incredibly generous with her time, for sure. Absolutely. Very, very generous with her time. Um, you know, she had just gotten out of the hospital again, so, you know, I knew she was sick, but I didn't know she was this sick. Maybe I didn't want to know that she was this sick, though, with her going in and out of the hospital as much as she was. Maybe I was just in denial about the whole thing. Uncle the Bailey's here. Just trying to process this as best we can. In-house, sorry for such a loss of such a positive person. Clearly, she impacted each of you guys and all of us as well. She was so generous with her time. She was so kind, so wonderful, so thoughtful, encouraging. She was just a genuinely good person. Thank you, Sandra, for the support. Um, as always, I appreciate it. Um, I don't know what to do or what to say, really. Um, I agree with this concept. We should do something special for her. I'm not sure exactly what that would be, but we should do something special. That's fair. That's a very good point. We should try to do something for her, um, in honor of her, whatever that would be. And uh, yeah, I guess I take some small comfort in the idea that the money we recently raised to help her with her home can be used by her family to help defray some of the funeral expenses. So, in the desperate effort to look for some sort of bright lining in this dark cloud, I guess that's something that's nice. Eh, yeah. Well, needless to say, the stream is over now. We won't be doing any further stories today. Florida man doesn't seem appropriate today. So we'll figure out something to do that will be hopefully nice. I'm gonna sign off because I need to just sit with this information for a while. Um, and I will try to figure out something we can do. Maybe we'll do a fundraiser for bird sanctuary or something someone suggested, or charity stream for her family or something. I don't know what that would be. Um, but you know, I am. I don't know what to. You know. I'm gonna sign off for now. I'm sorry. Uh, obviously, to Secret McSquirrel's family. Um, my heart goes out to you. For what I'm sure is a devastating loss. Um, I hope that you will know that she brought a lot of light and a lot of joy into other people's lives, and that she was a good person and a good influence, and that her absence will be missed, and that we care, and that we are so sorry for your loss. And please feel free to reach out to us individually or collectively if there's something we can do that it will in some way help. Uh, and that's all. Um, until later, my friends, goodbye.